All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here today in our case once again, SA170141, Clark versus KREAMER, CHAO, Real Party and Interest. Each side will have 20 minutes to present their argument. Particularly, you may save time for rebuttal, but keeping track of that time is is for you to do. We have a clock at the podium for that purpose. We are recording the argument today, and in a few days, you'll be able to see this argument on YouTube. As you begin your argument, please identify yourself and your client for purposes of recording. We've read the petition and all the papers. We've conferenced the case, so we're very familiar with the case and the issues at hand. So when you begin your argument, just be aware that you can launch right into what you want us to know. Counsel, you may begin.
Afternoon. May it please the court, my name is Keith Berkshire, attorney for Mother Kimberly Clark. The trial court below used three separate legal basis to set aside the paternity order from the parties' consent decree between mother and father in 2012. The court used fraud upon the court under 85C3. The court also used 25812E for mistake of fact, and then 85C1F. I'm going to address the fraud upon the court standard first. The result of the underlying set aside is that currently the child has one legal parent. With the paternity order and set aside, there is no father at this point.
I assume that if things stay as they are, that will be changed at some point.
Well, and that creates the second issue from the standpoint of what happens in that case, which may not be part of the appeal, but is relevant from the standpoint of what happens to Mr. Ramirez, given Arizona's and local parentis laws, the case law interpreted it, and so forth. I mean, for all intents and purposes, he's been relinquished to a in loco parentis standing at best, which under this court's case law and Thomas and others prevents him from having joint legal decision making, prevents him from having parenting time. He's only allowed visitation under not only the statute but under the case law, including cases like Goodman v. Forson and others, that the result of this is a very harsh result for Mr. Ramirez because of that. He's taken from parent to non-parent, which, as this court has stated, is a vastly different standard. Obviously, that's the backdrop for what the analysis is, and our position is, given the evidence and even the allegation, if completely true, it doesn't meet the standard of fraud upon the court.
Well, let me ask you about the legal backdrop here, because there's been a lot of talk about the difference between fraud and fraud upon the court, and I'm not sure that it's terribly significant given the legal authority, if any, for the result that happened here. Is it well, let's walk through this. Under 812, absent fraud or duress, a biological parent who comes in after the 60 days is presumptively out of luck. Would you agree with that?
If they signed an affidavit of paternity under 812.
Well, if
absent a court order, yes.
Yeah. And the statutory basis then for substituting one parent for another legal parent is 25812. I don't think it's a trick question. I'm just trying to make sure we're on the same page.
I think it's I'm not sure about that. I think it depends if there's just an affidavit of paternity versus court order. If there's an order, I think that when you read bond or so forth, I think you still have to set aside an order. So I think there's a difference if, for example, in bond, obviously there was no court order from the standpoint of the parties were still married. Mm-hmm. So we have a third party coming in to say that I'm the biological father. There's not an order in that case. All there are is presumptions under 25-814.
Substantive authority, though, is statutory. If any authority exists, that substantive authority is statutory, not rule-based, is what I'm getting
I think the ability to file a paternity case in and of itself would be statutory, so which would be anywhere from 812, 816, and so forth. But the ability to set aside, you're going to end up with conflicting orders, so it would be rule-based to set aside the prior pre-existing order.
And what I'm getting at is, in the absence of the statute, do you believe that the rule would confer the substantive authority to enter an order like the one that was entered in this case, if the statute had never been enacted?
Well, I think you have to have a statute to allow somebody to file a paternity case in the first place. So I think there has to be a statute to do a paternity case.
It's not what I'm getting at, and I don't want to hang you up too long. But I think it's important for both sides that we have a clear map of the legal landscape here. Forget about filing a paternity case. If you have an order of paternity that came about as part of a dissolution case, okay, and that order is to be set aside and another party given rights, the rule alone would not allow that result.
The rule alone would not allow the second case, I'd agree.
Okay. And if that is true, then is the distinction between fraud upon the court, which is rule-based, and some general kind of fraud, which is statute-based, dispositive?
I think in setting aside the first order, I think it is. Whether the establishment of the second case, but I think, again, here the only issue was setting. We haven't gone down the rest of the case here. We're sitting on, did the court use the right authority to set aside this order? Not whether they needed to, I guess. It's did they use the right authority in setting aside this order? Because that's the procedural setup, what was argued in the underlying case.
Is it your view that the setting aside of the order is independent of the facts that would give rise to the right to establish paternity under 812E?
Obviously, they're related. But I don't think that the statute allows for two, without setting aside the order, I don't think the statute would allow for multiple paternity orders over the same child. So I think that's why procedurally you have to set the one aside. I don't think you can do a second one. It's convicting
but
five different people of the same crime. It's the first one is.
In this case, on this record, the order was set aside because of the specter of the rights of petitioner. Under 812.
Well, I don't believe so. I think that the entirety of the case about whether there was fraud upon the court was based upon mother's actions. All of the findings, all of the legal basis was for setting this aside was based on mother. It wasn't should father come in. That was a different hearing. This is was the correct legal analysis in setting aside the order under fraud upon the court.
Okay.
And frankly, Judge, there's not a lot of case law on this. The issue of, we have basically bond, which was, can somebody come into a marriage? There's no court order in the marriage. So this exact scenario hasn't been flushed out in case law, whether it's a rule or the statute, because the other cases have all been, can somebody come into a intact marriage and do that? We're not trying to set aside an order in those because obviously married people don't have orders that this is my kid or so forth. Or most don't.
They do have birth certificates, though.
And which is a presumption and still not an order, despite 816, which says they have the same validity. But the underlying issue still is of what was litigated and what we're appealing is fraud and fraud upon the court the same?
Well, and counsel, I wanted to clarify. It seemed from your pleadings that you were arguing the trial court applied the wrong standard in determining fraud on the court. And then today, at least in the few minutes we've allowed you to speak without questions, I understand that you're arguing the trial court was just plain wrong in finding fraud on the court. And from my reading of the record, and I'm sure you may disagree, it seems like the court applied the right standard, and if it did, if it comes down to was the court right or wrong, we view that under an abuse of discretion standard, and how do you overcome that?
And I understand it. To some extent, it is a mixed issue of the application of the facts to the law versus just the court stated the wrong standard, just I'm going to follow this versus another one. Our argument is twofold. One, that they used a common law fraud standard because this doesn't reach the egregiousness of the requirement for fraud upon the court. The second is that just the facts in and of themselves can't. I mean, the closest case on point to this is really the Pinter case that we cite to, which is, unlike the Alvarado case, where both parties, mother and the other fraudulent perpetrator in that case, where they tried to do an adoption in family court, essentially, they both knew there was the unconscionable act and deliberate action to defraud the court. Here, there's no way that these facts, even if true, could add up to that. And so it is. I understand it's an application of the facts to the law on it, Your Honor.
And are you saying, as far as husband goes, there's no evidence of fraud?
Well, and that is definitely one of our arguments, that since he is the one that essentially is being penalized here, Mr. Ramirez is the one whose rights were taken away. The court specifically found that nothing illegitimate on his behalf, and he is the one that is being punished. Mom didn't lose rights to the child. She's still the mother. But Mr. Ramirez did when the court specifically found he did nothing. So the fraud would essentially have to be twofold there to set aside, it's mom committed something to set aside his rights. That can't be the standard.
Well, does the statute deal in punishment, or is it just to correct an erroneous legal ruling or determination because someone in the case has committed fraud? I mean, is the statute, is the purpose of the statute to punish the fraudster, or is it just to correct the fact that an erroneous ruling was made because of fraudulent activity on someone's part?
I don't know if it necessarily obviously doesn't utilize any language like that. All of the case law does. I mean, in all the cases, the person who has the ruling against them is to use your word, Judge Howe, the fraudster. And I mean, the McNeil case, Alvarado, all these, all of them, it was the person who perpetrated it. Here, the person who, even though we disagree that there was any perpetrating fraud here, father is a victim of what he's really the only victim of the order. I mean, mom.
I don't know if that's entirely true.
There's
a child here.
I was going to say besides.
And nobody has mentioned the word best interests today, but you did mention the Bond case. Do you believe that the Bond case's incorporation of a best interest standard still is good law under current statutes?
Being that it's been cited so many times, I'd be hard-pressed to say that it's not. I mean, Bond is repeatedly cited in cases. There's on Supreme Court, and I think this court has used it recently in a couple that I know that I've argued. So it is. I mean, that best interest analysis and something like that is still out there. But the underlying, I think, the big main point on the facts of this case. Again, it's closest to Pinter in the fact that you don't know. I mean, every fact in this case, or every allegation that mother committed fraud, comes down to one thing. Should she have known that the kid looked Asian? I mean, to cut through it, that's it. That's the evidence. You should have known. There's no question that there was sexual intercourse between both petitioner and Mr. Ramirez in the same time, that she could have gotten pregnant from either. There's no question on that there was, nobody's saying that there was no intercourse with Mr. Ramirez, that he couldn't have been the father, as in the Alvarado case, where there was no question they'd never had intercourse at all. So the issue is, every fact comes down to, should mom have recognized that this kid was Asian instead of Hispanic? And every finding of any kind comes down to that one issue. And that can't be enough for fraud upon the court of, should you have recognized? Everything else is these blatantly purposeful.
But what if you tell the court something that you believe sincerely to be a falsehood, whether you should have recognized it or not?
Well, there's case law that says your belief, if it was a sincere belief, is not fraud upon the court. It's this purposeful.
No, I'm sorry. I mixed up sincere and falsehood for effect. But if you believe deeply that you are about to lie to the court, however vague the facts may be objectively, isn't that enough?
I don't believe so. If we look at the McNeil case, they talk about that even misleading the court, even perjury, is not enough to do fraud upon the court. Paying someone to perjure themselves is fraud upon the court, but perjury or misstatement of facts or misleading the court doesn't raise to that next level. So at most, it would be misleading in this point, but not the purposeful. I mean, the examples when we look at, there was just a Ninth Circuit case that came out last week on fraud upon the court, and it used the same that it's the most egregious cases. It's not just fraud. It is the most egregious. It is only when you are completely disrupting the legal system. And that's how the difference between the Pinter case we cite and Alvarado, the parties in Alvarado went in saying, let's just do this concocted adoption. We get a paternity order out of family court, and both parties completely knew 100% that there was fraud. The McNeil case, I'm going to lie and try to throw the husband in jail, my ex-husband in jail, to enforce spousal maintenance, despite the fact I've 100% known I've been overpaid. So the action of trying to throw him in jail, despite that, those were the fraud upon the court. But those are the most egregious cases, not just you should have known. And again, it comes back to...
Counsel, as you say, the issue becomes, did mother know the child was Asian or not? The trial court took evidence on that point, and he very clearly found in the record that mother was not credible on that point. Why isn't the trial court entitled to make that credibility determination with the consequences that follow from that?
They are.
And assuming that the trial court can, how can we, as an appellate court, say that the trial court was wrong in making that credibility determination? That comes back to my earlier question. That on this issue, the standard of review for us is an abuse of discretion.
And I understand. Obviously, I'm not here to challenge, can the court make a credibility determination. The findings that I find mom not credible in those, clear abuse of discretion standard, I'm not here to argue that those, you should set those aside or not follow them. The issue is, on its face, what was even alleged isn't enough. So whether the court sided with Mr. CHAO and found that she wasn't honest, and so forth, but that's not enough. The issue is, even the allegation, it's almost like a summary judgment. You didn't allege enough to even meet the claim. And that is because everything comes back to, should a parent be able to recognize the ethnicity of a mixed race child, whether the child was Greek and Hispanic or Greek and Asian? Are we putting that burden of, it's not like she had a DNA test. If she would have done a DNA test when the kid was born and hid it, okay. That's not the case. You're saying that recognizing the race of the child is, there's such a high standard to be able to recognize the race of this mixed race child. And that's the issue here, is that where's the line? If it was, 50%, of certain race, I mean, where is that line? That allegation doesn't meet it on its face. So I'd like to save the last minute and a half for rebuttal.
Sure.
Thank you.
Thank you, counsel. Counsel?
Good afternoon. Michelle Roddy for Real Party and Interest Clarence CHAO. Mr. CHAO wants to be a parent. From the moment that he learned that he was a father, he never wavered in his resolve to be a parent. And that's the reason why he initiated the paternity lawsuit, which is now about 2.5 years old.
Would you agree, though, that had fraud not been in the atmosphere in this case, that his paternity action would have been doomed at the time he brought it as a matter of Arizona statute?
I don't agree with that. I think that
Under what
812,
authority, if there had been no fraud at all, just a simple error and his biological status established clearly, under what authority would he have been able to seek paternal rights?
I think he would have been able to seek paternal rights to undo the consent decree from 2012 under Rule 85C1F.
So, well, is there any statute that would allow that? Because the 812E seems to make very clear that the 60-day limit applies unless there is fraud. So to just say, well, we're going to ignore that 60-day limit under 812E and just go under Rule 85 would seem to be a separation of powers concern.
Well, it's not only fraud, it's duress and mistake under 812, right?
Okay.
So are you assuming that we blow up all of 812 and that doesn't exist? That's your question? How can he
Put it that way. I'm asking whether in the absence of what is in this case fraud, right? That's the allegation. In the absence of fraud, and it's not just mistake, by the way, it's mutual mistake. In the absence of fraud, duress, or mutual mistake, would there be any grounds upon which your client could have actually pursued paternity rights?
I 814, I actually am not, hold on just a second here. Nobody is presumed the parent in this case, under 814.
Well, that's not my question. That's not my question. In this case, if there had been no fraud, if there had simply been a unilateral mistake on the part of mother, and let's say that your client had no idea of the child's existence for 10 years, comes in and says, guess what, I just realized I'm the biological father. Is there any legal basis for him to succeed at that point?
812 is the only statute that I think gives him the ability to come in there, although he has some rules-based ability to overturn
well,
their
I think the rules do provide a process to affect the substantive law, but we would agree that the substantive law comes from the statute. That's what I'm getting at.
I believe that all of the parental rights involved in this case flow from the legislature. They are the ones who create the laws, who define parenting, who define parents.
Right.
And so the other, I suppose, authority, although I don't know that he could initiate an action based upon a definition, is under 25401, which is a legal parent under subsection 4. Legal parent means a biological or adoptive parent whose parental rights have not been terminated. That would be my client. He is a biological parent. His rights have not been terminated. Can he initiate a lawsuit based upon a definition?
There's evidence that he's the biological parent, and certainly, there are some ways this case could come out that would allow him to present that evidence and become the biological parent. But I think saying that he is the biological parent at this point is maybe jumping the gun a little bit. The evidence is overwhelming, I'll give you that, but that has not been formally established as a legal matter at this point.
The court has not ruled as to biology, but the evidence, the scientific evidence, points to biology.
Clearly, no doubt about it, which is why I think 812E refers to genetic tests and clear and convincing proof, and only allows that proof to be offered in certain circumstances. So here, the allegation is there was fraud. Let me ask you about a hypothetical that may seem far-fetched, but I use it to help me frame the issue in my own mind. Let's say that neither parent or putative parent had been involved in any fraud, but the statute, someone at the hospital falsified a record, committed fraud, giving rise to the belief on the part of the putative father that he was the father, when in fact genetically it's clear that he was not. Okay? Fraud was committed. Is that enough to give your client rights under 812E?
I think Hall versus Lawley would have us analyze the child's interest in determining biological parentage.
I think you may be right.
So I'm not sure that we would need to get there.
Well, I think we always need to get through the statute before we can get to the case law. So let me just ask you, under the statute, if we have this rogue hospital worker committing fraud on two innocent married people raising a child, does 812E give your client rights? There is fraud. Your client is the biological parent according to the evidence. Does he have rights in that case?
.812E does not identify who commits the fraud.
That's kind of my source of confusion, yes.
Okay, so 812E allows a mother, a father, or a child, so presumably through a best interest attorney, to bring an action or to a motion to rebut the presumption of paternity on the basis of fraud, duress, or material mistake of fact. It does not identify who committed those acts. So yes, I believe under 812 it would.
So a third party who may be long gone, who may have died, that person's fraud can work to the disadvantage of this family under the statute. Can we fairly infer that the legislature intended that result?
I haven't read the legislative transcript on this, but
you won't find it, I'm sure.
This case to me speaks directly to what the legislature intended when they wrote this statute, which is a person who wants to be a parent, who indicated so from the very beginning, who was lied to by a mother, who the mother was unwed at the time of birth, who there's no child listed, there's no father listed on the birth certificate. This is the exact scenario that I think that the legislature had in mind when they enacted 812E.
Is there any finding in the trial court that mother lied at the time of birth?
The court made no factual findings about that particular.
I thought
there was some evidence that went back and forth, but no findings.
Right. I mean, our record just has the court finding that mother committed fraud on the court, and I'll use that term loosely for right now. We can fight over the definitions later. But mother committed fraud on the court at some point. But there was no finding, I believe, that she committed fraud at the time of birth.
There have been no evidentiary findings on that particular matter. That's correct.
But counsel, would the court necessarily have to find at the time that the consent decree was entered into that mother knew that Mr. CHAO was the biological father? Is that correct? Because otherwise there wouldn't be a claim, correct?
Absolutely. I think in order for us to meet the standard that was articulated in McNeil, we had to prove that mother knew at the time that she submitted the consent decree in 2012 that Mr. Ramirez was not the biological father. She may not have known with certainty because we didn't have, she didn't have evidence of a DNA test that Mr. CHAO was the biological father. But the court found that she knew with clear and convincing evidence that in 2012, Mr. Ramirez was not the biological father. And so, yes, I do believe we had to prove that, and we did with clear and convincing evidence at the trial court.
Okay. You mentioned earlier the importance of best interests that emerges from several of our cases. Best interest is not a term we see much in the briefing here, and it's not a term that appears in Section 812E. Does it have any role in our decision of this case?
There have been no evidentiary findings yet on the best interest, and that's because, in this case, the mother and Ramirez completely avoided the adoption process. That would have been the route by which they could have actually completed and made Mr. Ramirez the legal father. And going through the adoption process necessarily...
That's an interesting point. What if they had done that? Let's say that this case were procedurally cleaner, and they went through an adoption process without giving any notice to your client.
He has the ability to challenge that. An adoption process necessarily includes a review of the putative father registry. It necessarily includes a best interest finding from the judge, and it also includes notice to my client.
It might not include notice to your client under my hypothetical. He's not in the putative father registry, correct?
I believe he is now.
Well, okay, but at any relevant time, he was not.
That's correct.
Okay. And so if the adoption proceeding goes forward, either through ill intent or innocently, without notice to your client, does he then later have, on the child's 17th birthday, the right to come in and seek paternal rights?
Well, the adoption statutes require, at a minimum, if they don't give Mr. CHAO actual notice, which he did not receive in this case, he would have had to receive notice by publication as a right. And so the adoption wouldn't have proceeded without notice by publication. So
I'm going to assume, though, that in the real world, if notice by publication generally had been issued and Mr. CHAO's paternal status had not been suspected by mother, let's say she had no reason to believe it was a fluke, and she didn't recall his existence, but there was some general notice by publication, he didn't respond. Where are we then?
we're at a completely different result.
Okay.
I don't think that there would be, the grounds would be much more difficult to challenge because of this court's, I think this Court of Appeals, holdings that innocent adoptive parents are given rights when this is not a case of innocent adoptive parents.
I understand, and I'm asking you about, I'm changing the facts a lot to illustrate different points along the landscape, just so I can help get my head around it. I'm not trying to mislead anyone. So if we take the proposition you just uttered, that there's a completely different result in that case, then let me ask you this. Assuming no fraud, is there any difference in the legal effect between a paternity order and an order of adoption? Is one weaker than the other?
Yes,
Assuming no fraud.
yes, there is. A paternity order is weaker because through the adoption process, there is necessarily a finding of best interest. Here, there has been no best interest hearing. We're hopefully going to come up upon that.
That's an interesting slippery slope, because there's no best interest determination when two people are married and have a child. In fact, there's often no best interest. But the reality is that the legal presumption of parental rights is so strong as to be one of the most powerful fundamental rights we have, without a best interest finding. So you may not want to go down that road.
Well, you don't have to get, you have to get a driver's license in order to drive, but you don't have to get a license in order to have a child. And so we're not going to create some kind of process, or the legislature didn't create a process by which everybody who has a child has to go through a best interest hearing. But
are the fundamental rights of a person who has a paternity order less than those of somebody who has an adoption order?
The fundamental rights, I do not believe, are different, but I think that you are also assuming that we have a real valid paternity order here.
I am. For purposes of the hypothetical,
Yes,
I am.
then yes, I agree with you.
Yes. Okay.
If this case proceeds the way that the trucker has already ruled, is it possible that at a subsequent hearing, the trial court could find that Mr. Ramirez should still have legal decision-making authority that Mr. CHAO should not, even though Mr. CHAO is the biological father?
So, yes, under 25409, which is the in loco third-party rights statute, the court does not have to find that my client is entitled to any parenting time whatsoever. If the court finds that it's not in minor child's best interest, he may never meet the child at this point. But my client, our position is my client's at least entitled to an evidentiary hearing where we have a best interest attorney that gets to participate in that and take discovery and figure out what is in this child's best interest.
And I'll ask an earlier question I had earlier about a response you had to Judge Swan. You discussed what the possible the legislative intent of 812 would be. If the language is plain, do we get there? Do you believe the language is plain? In terms of fraud, I mean, does fraud, given your earlier answer, fraud give you the fraud could be committed by anyone if it caused an improper or wrong judicial ruling?
I believe that's correct. I don't think that under 812 we have to prove fraud upon the court. Under 812 we can prove fraud occurred between mother and Mr. Ramirez, that fraud occurred between mother and Mr. CHAO. It doesn't have to, it's not necessarily
at the hospital because of some unknown hospital work.
That's right.
That's good enough. The Supreme Court recently told me that when we have two sides arguing that the statute has plain, unambiguous, and opposite meanings, that is not an unambiguous statute. I just observed, just so that everyone knows I read those opinions, that we do have two sides here saying that the statute is very, very clear, and I'm not so sure it's so clear.
if you were to use hypotheticals, for example, some of the stuff that's going up in the Supreme Court now with lesbians and artificial insemination, it may not be as clear. But when you read it from Mother and Ramirez's perspective and Mr. CHAO's perspective in this case, I don't see any way that I can interpret this statute any differently. We meet the statute.
Well, I mean, but you through the hypotheticals, we've arrived at the idea that you interpret the statute to mean that any fraud by anyone at any time leads to this result. And you don't think the statute is susceptible to any other interpretation. One would have to be unreasonable to read it otherwise.
I'm open to some hypotheticals that would help me get to
I'm
your.
wearing you and the panel out with all these hypotheticals, but one of them was, I really do have to wonder whether if the legislature were presented with the case of two happily married parents raising their 17-year-old daughter who had been placed in their care by the fraud of a now deceased hospital worker, if the legislature really contemplated tearing that family apart.
I don't know if the legislature contemplated it, but the Court of Appeals did contemplate that exact scenario in Ban versus Quigley. So when you have a married couple that is married at the time of birth and has an intact marriage along the way, in order for some third party to come in and undo that, the court has to have a best interest hearing.
Which is nowhere in the statute. The court. I mean, I'm not questioning the authority of that decision, but when we start talking about rigid statutory construction methodologies, and we see that our case law has been injecting a standard that the legislature didn't write, does that cause you any discomfort?
it has caused me a lot of late nights reading Court of Appeals decisions, like I'm sure one that's going to come out here, trying to figure out how we navigate the legal system. The lower court here did extensive research to figure out, and this case has gone on a long time, to figure out, do we have to have a best interest hearing before we even had a genetic test, which the court found that we did, or held that we did. So we had to have an evidentiary hearing to determine whether we could even have a genetic test. And then we got the genetic test. And so yeah, yes and no. I think that there have been a lot of procedural questions that are unclear, but I don't think the statute's unclear. I think some of the procedure and how we get there, how do we get to the genetic testing, how do we get to a best interest hearing, I think that's where this case has had multiple hang-ups.
Thank you.
Any other questions? Thank you.
Thank you. Counsel?
I guess I still challenge to some extent that 812 is the authority here on the new action. Because 812 talks about setting aside a voluntary acknowledgement of paternity. That's not where we're at. We're at a court order. 812 doesn't talk about setting aside a court order. It's just about voluntary acknowledgements of paternity. I think that the new action would be more likely filed under 25806, which then is what implicates the rule application of fraud upon the court that you're trying to set it aside under a rule. Because 812 is, again, 812 is cases where somebody is trying to set aside, they signed it's an unmarried couple that signs the voluntary acknowledgement of paternity at the hospital. 812 doesn't talk about the order that results from that voluntary acknowledgement. It's only the actual acknowledgement. We're not there. We are at a court order stage. So this gets to how do we, can he file? Yes, under 806, anybody can file. I can file. But to set aside that order, that's why I believe that we have to look at the strict interpretation of 85, which would be 85C3 for fraud upon the court versus just fraud under 812.
Well, it seems to me that 806 is a very basic statute with no substantive provisions. All it does is open the doors to the courthouse. The order, and correct me if I'm misunderstanding the record, but the order that was set aside in this case was set aside on the strength, I believe, of the specter of an impending 812 action.
Well, they filed under 812 as one of the multiple claims for relief of how they could get around this. Interestingly, like I said in our brief, they didn't actually ever file under C1F. They pled that in their pretrial. It wasn't ever actually pled properly. But it was originally pled under an 812E case, but that wasn't again, I don't believe that 812 applies because it's not, 812 doesn't deal with orders. We'd have to go to the rules for the orders. I know I'm out of time.
Thank you, counsel.
Thank you very much.
We appreciate your argument today. We stand adjourned and we will issue a decision in due course. Thank you.